I think we'll get underway now. I know people are joining, but we would like to kind of stick to our timeframes. I'd like to welcome everybody to the Cleaning Accountability Frameworks webinar on the implications of the Modern Slavery Act review for the Australian cleaning sector. My name's Jasper Goss. I'm the Director of Certification and Compliance at CAF, and today we're going to be joined by two experts and, in fact, also a leading practitioner within the field and a person who is also has direct experience and work with CAF. I'd like to begin with an acknowledgement to country. In the spirit of reconciliation, CAF acknowledges the traditional custodians of country throughout Australia and their unceded rights and connections to land, sea and community. We pay our respect to their elders, past and present, and extend that respect, to all Aboriginal and Torres Strait Islander peoples today. I'd like to just note to everybody that your camera and microphones are muted and turned off at the moment for privacy. And I'd also like to inform everybody that the meeting today will be recorded. You will note that there is the possibility for Q&A. We're going to ask people to, if they have a question, just to tap it in the Q&A chat box, which should appear. There should be an option at the top right of your screen to be able to press and then put in a question. Please put in questions as we're going through the presentation, and at the end of the meeting we'll have a time for about 15 minutes for Q&A. I'll collate those questions and present them to the presenters. I'd just like to sort of give an introduction to CAF itself. I think many of you will be familiar with CAF, but some of you may not be. And CAF has previously been recognised, sorry, let me rephrase that. Cleaning has previously been recognised as a key risk area for modern slavery in Australia by many stakeholders, including the Department of Home Affairs. The withholding of wages, immigration-related coercion and threats, deceptive recruitment, excessive overtime, debt bondage, confiscation of personal and travel documents, and dangerous and substandard working conditions are all practices that have been found within the cleaning industry in Australia. The Cleaning Accountability Framework was created to directly address these issues. CAF is an independent, multi-stakeholder initiative that seeks to improve labour standards in the cleaning industry in Australia. CAF promotes the rights of cleaners, responsible contracting practices and transparent supply chains. We do this through the CAF certification scheme, recognising and rewarding good practice in the cleaning industry. CAF has been recognised as an anti-slavery mechanism by leading business and human rights experts for the work we do in relation to worker-driven compliance, robust third-party auditing and tripartite collaboration in education. The CAF core principles, the CAF 3-star standard, the CAF pricing schedule, a mechanism to bring transparency and accountability to contract pricing, and CAF's unique worker engagement model were derived through our stakeholders' collaborative efforts. We're also very much active in the policy spaces, and obviously for many people, what has emerged, especially since 2018 in the introduction of the Modern Slavery Act, has been much greater attention around supply chains and sourcing. Part of the Modern Slavery Act included a provision for a review of the Act, which began last year, and CAF also made submissions to that review. In our review, we focused on the recommendation for the creation of an anti-slavery commissioner. We also encouraged the adoption of approaches that focus on high-risk sectors, of course, which cleaning is one of them. We felt that there was a need to increase transparency within the Modern Slavery Statement register, as at present there's no differentiation between companies that are in compliance with the Act and those that are not. And we also called for a broadening of the advisory group that advises the minister responsible, although now it's a different minister and presently under the Attorney General's Department. We note that the review of the Act that took place was one of the broadest and largest, I think, in recent times of any act, and is considered by some to be a great model of consultation and recognition of the kinds of issues that were presented. The review was concluded in May and made 30 recommendations. And today we're joined by two speakers who are going to comment on those recommendations and the implications that they have specifically for the cleaning industry. Firstly, and more broadly, for business. Firstly, I'd like to welcome Justine Nolan, who is professor of is a professor at the University of New South Wales and is the director of the Australian Human Rights Institute. She's been active in the space of modern slavery and human rights in business for many, many years and is an internationally recognised expert in the field. I'd like to introduce Justine. Thank you.
Thank you, Jasper. Sorry about that delay in unmuting myself. And thank you to CAF for setting up this important seminar and you all for joining us, giving up your time and joining us today. My role today is to give you an high-level overview of the review, what it found, and where I think the movement's going to happen as we go ahead in this area over the next year and few years that follow. So let me start with the review and then I'll talk a little bit about the implications. As Jasper said, the review that was conducted by Professor McMillan, which you can access in a public document online, was a really thorough and well-researched and well-consulted document. And he has recommended 30 recommendations that are aimed at strengthening modern slavery responses. And I'm just going to comment on a few of those with it. But overall, what we're seeing is that what the review sort of highlighted, that the Modern Slavery Act has been very useful in raising awareness of these issues, in educating business in particular about the need to understand their responsibilities in their operations and supply chains around modern slavery, but it has been far less effective in driving change and actually creating meaningful and effective change on the ground. I've been part of a consortium with 4 other universities and 4 NGOs over the last 3 years, which has been undertaking a project which has been testing the effectiveness of Modern Slavery Act. And you can see our multiple reports on the website of the Australian Human Rights Institute. And the outcome of those reports is much like what Professor McMillan found, is that in many cases there's been change, but not what we would call effective change. There's a clear differentiation between some leading companies that are a mix of large and small entities at the top of that, but there's an awful lot of companies in the middle which we would argue are taking more of a box-ticking approach to modern slavery reporting. So the review is a chance for Australia to improve its response, because it's no point having a Modern Slavery Act if it's not creating change. It's not about just instigating another regulatory burden on companies to report. What we actually want to do is tackle the problem of modern slavery. And at the moment, the way that the law is set up, it doesn't appear to be doing that. So let me focus just on a couple of the recommendations that Professor McMillan found. So one of the most significant is that what he is arguing, and what many submissions argued, including ours and that from CAF, was that we need to have something more than reporting. And what McMillan has suggested is that reporting entities need to have what's called a due diligence system in place that will identify, monitor and address modern slavery risks. And I'll come back to this in a minute, what that means. He also recommended introducing penalties for reporting entities that fail to submit a modern slavery statement, for including false information in a statement or failing to have a due diligence system in place. So at the moment, many of you would be aware that there is no real enforcement regime under the Modern Slavery Act. Those companies, and our research found that there are several companies who are simply failing to submit modern slavery statements. At the moment, there is very little sort of compliance around that. So it's recommended that we have a stronger enforcement framework. And this is a platform that the current Labor government came to power in. And so it's something that we expect that the government would follow through on. He also recommends that the government should establish a central complaints mechanism. So this would be a body that, in particularly those impacted by adverse working conditions, could centrally make a complaint to government that would be recording what is going on in their workplace. Another recommendation is to introduce a new reporting requirement under the law that would require reporting entities to report on their incidence of modern slavery in an annual fashion. So at the moment, if you look at the reporting, it's fairly hit and miss. Some companies are actually identifying where modern slavery is present in their chains or where they think it is, and others are simply ignoring that. The whole idea around this law is to sort of socialise and normalise the risks that we're finding. We know that there are modern slavery in many operations and supply chains. That's not news. But we're not going to fix it unless we become more transparent about it and we accept these reporting, that companies should be finding this. And then what we're focused on is how you fix it, not so much just the fact that it's there. And then also, as Jasper mentioned, the establishment of an anti-slavery commissioner and an office that is well resourced to support that. This again was another mechanism that Labor came to power on, a part of their platform, and we know that work is already underway to establish an office of an anti-slavery commissioner. One other recommendation that was made by Professor McMillan was that the reporting requirement should be reduced. So at the moment, reporting under the Modern Slavery Act applies to entities that are $100 million and above, and it has been suggested that this should be lowered to $50 million, which would be more consistent and in line with the current UK modern slavery reporting requirements. So what are the implications of this for you and your business in relation to it? Probably the most significant change and something to understand is that the law is going to change. There is no doubt about that. And what we're likely to see is more significant and substantive efforts that are required from companies in relation to a response from the law. I think in the short term, we will see the establishment of an anti-slavery commissioner and their office, and we will also see the introduction of penalties. But I think over time, what we will see is also this concept of human rights due diligence being introduced. So what does this mean? Basically, what it requires is companies to act, not just report. The focus on the Modern Slavery Act at the moment is all about reporting, but it leaves out that crucial step is that you can't report unless you've taken all these actions to identify risk in the first place. So human rights due diligence comes from something called the UN Guiding Principles on Business and Human Rights, which sets out a global framework for how businesses need to think about human rights. And due diligence in this concept is all about companies identifying the risks that they pose to others. So it's not about risk to the company, it's about the risks that the company and its activities pose to others and its workforce, its community, more broadly. So due diligence basically has these steps, 4 steps. First of all, it's looking at identifying and assessing actual or potential harms that a company might be causing or contributing, then taking action and tracking the effectiveness of what you're doing, and then also communicating publicly about that. Those 4 steps are part of this broad concept, which is known as human rights due diligence. And Lauren's going to talk about that a little bit more in the context, particularly of cleaning and CAF and what that means more specifically. But for you, it's also trying to understand the benefits of while you're doing this. And for some, it might be, talking about the benefits within your own company, but it might also be talking about the benefits within suppliers or with partners that you work with. Because you don't want to just do something because the law requires it. There wants to be a benefit and a business case for doing this. And the understanding around human rights due diligence and what we're seeing in other jurisdictions is that it's actually providing increased certainty and level the playing field between businesses around how they're responding to this. We're seeing better relationships between companies and their suppliers by applying this concept of due diligence. And it's very much sort of a partnership mode as opposed to a policing mode. So the old way of doing this, if you look back 10, 20 years, was to think about a company constantly policing their suppliers, constantly thinking about, we need to audit them, we need to find out what you're doing. Where human rights due diligence is asking for something different, it's sort of saying, we're in this together. Our supply chain is something that is a shared shared value chain, and we need to work together to improve this. So we need to think about more how we work as partners rather than sort of command and control approaches. And we also need to sort of keep reminding ourselves of why we're doing this. We're basically trying to identify worker abuse in operations and supply chains and stamp that out. And what sort of can we do effectively to address this? At the moment, companies are spending tens of thousands of dollars on reporting, for, in many cases, few results. So it's just not an effective way of working. So we have to think about how we more effectively garner corporate action in order to change and improve respect in the workplace. And what this is basically doing is we're seeing that this is part of a global trend, particularly coming out of Europe, but also other jurisdictions. So we have seen new laws just in the last few years from France, Germany, Norway, and Netherlands, which have gone beyond reporting and are requiring companies that are relevant to those jurisdictions to conduct this concept of human rights due diligence throughout their supply chain. We've also seen demands for the UK law to be updated in similar ways to ours. And this year, the European Parliament showed the first signs that they will introduce a broader EU directive on corporate sustainability and due diligence that would apply across the EU, and that would require companies within that jurisdiction, wherever their supply chains end up, to conduct human rights due diligence. So we're seeing a change in approach, moving beyond reporting to actual action with it. And it's anticipated that the EU law will continue to process through the system probably for the next 6 to 8 months, and will come into operation sometime between 2025 and 2027. We're seeing similar laws that are being discussed in New Zealand, in Canada, in Hong Kong. So what we're seeing are a global trend to basically require companies to do more. So in summary, the Australian review is in line with what we're seeing these trends overseas, and the urgency for companies is to basically stay up to and get ahead of those trends. We want to move beyond reporting and start to think about what work you're doing can actually create change. So I'm going to hand it over back to Jasper now, and then we'll come to Lauren to talk about the implications of this for the cleaning sector.
Thank you very much, Justine. And just a reminder again, if you have any questions, please pop them into the chat box and we'll come to them at the end. I'd now like to introduce Lauren Zanetti, who is a non-executive director and member of the CAF board. Lauren is I hope I'm correct in saying this, is a practicing lawyer, but correct me if I'm wrong, please, and has extensive experience working with companies in framing and crafting and refining modern slavery statements in compliance with the Act. Thank you very much, Lauren.
Thanks so much, Jasper. Thank you very much for having me here today. Yes, and as Jasper mentioned, I'm very pleased to serve the CAF board as an independent non-executive director. I'm here today in my personal capacity, but my other hat is as an associate director at the business and human rights advisory firm called Pillar 2. And at Pillar 2, we work to help businesses globally understand and address their human rights risks, including modern slavery. So as Jasper mentioned today, and I should correct you, I'm not a practicing lawyer at the moment, but my background is as a lawyer. Thanks, Jasper. But today I'll be reflecting on some of the review's recommendations, some trends in modern slavery reporting to date. And then as Justine foreshadowed, I'm just going to share some of my personal views about how the CAF certification process really is a good example of this human rights due diligence process in action at the end of my discussion. So I'd like to start just by building on some of Justine's comments, particularly about that big recommendation about the potential introduction of a mandatory human rights due diligence obligation in the Act. So my view is that one of the key benefits of modern slavery reporting to date is that it's been an entry point for Australian businesses to start to learn about and start to implement the expectations of those UN guiding principles on business and human rights, which Justine was just mentioning. And as she mentioned, they're this authoritative global standard for preventing and addressing human rights related harm arising in relation to business activities. And a fun fact is that the Australian government actually co-sponsored the adoption of these standards at the UN in 2011. As many of you would know, the Australian government's guidance for businesses reporting under the Act actually suggests that businesses should already be using this process of human rights due diligence to manage their modern slavery risk. This is the process that Justine has already outlined for you, and as she's mentioned, it's really a risk management process that looks at risk to people rather than just primarily risk to the business. And the steps that are involved in human rights due diligence map on basically to the mandatory criteria in the Modern Slavery Act. And as Justine has also flagged, this recommendation for the introduction of a human rights due diligence obligation really is in step with a wider trend of the introduction of similar laws, particularly in Europe. And as she mentioned, similarly, New Zealand, Canada, and other jurisdictions are thinking about introducing similar obligations for businesses. So the key point I'd like to make here is that even if this mandatory human rights due diligence obligation doesn't arrive in our updated Act, it's actually just becoming an increasing expected norm of responsible business conduct. So, for example, if your business is selling to a business that's subject to one of these mandatory human rights due diligence laws, in France, in Norway, in Germany, potentially across the whole EU shortly, that means you're in the supply chains of these businesses, and your business is likely to find itself subject to increased scrutiny from your customers about the human rights due diligence that your business is undertaking itself. And then even if you don't sell to these markets, you might be an Australian cleaning business, you might be a property company that only has an Australian footprint. I guess the wider takeaway here, which I think is really echoing what Justine was saying, is that human rights due diligence, which the UNGP should be done proportionate to your business's size and your context and the type of risks you're dealing with. Human rights due diligence is really increasingly becoming this expected norm of responsible business conduct, and that expectation is coming from governments, it's coming from your B2B customers, it's investors, and it's also civil society. Jess, if you could pop to the next slide, please, that'd be great. I'm just going to now just reflect on some of the reporting to date. So there's been a range of investor and civil society benchmarking and commentary over the first 3 years of modern slavery reporting. And this year and last year, Pillar 2 was commissioned by the Australian Council of Superannuation Investors to benchmark ASX 200 companies' modern slavery statements. So I'm just going to touch briefly on a couple of findings from this year's AXI report. The first one was found that ASX 200 companies were disclosing in their statements that foundational actions are being undertaken to manage modern slavery risk. So we're talking about things like supply chain risk assessments, use of contract clauses, internal training and collaboration. However, the observation that came out of this benchmarking was the change that is happening is really fairly incremental. And there's only really that small cohort of leading businesses in that ASX 200 that are disclosing that they're taking more advanced action to manage those risks in their operations and supply chains. So we're talking here about things like actually working with your suppliers to build their capacity to manage their own risks, building internal capacity, particularly at those senior levels within business, for example, at board level, making sure that your grievance mechanisms work and that you've taken steps to make sure that they're accessible, and engaging in external stakeholder consultations, which I'm going to come back to. We also know that modern slavery risks can often be fairly deep in your supply chain, and your first tier might not be your highest risk area. But having said that, only 14% of the statements that were reviewed as part of this AXI report contained information about businesses' supply chains at tier 2 or below. So we know these early years of modern slavery risk management responses have involved businesses getting a handle on that first tier of suppliers, but now leading practices involving businesses looking deeper at where the risks are more likely to lie. We also know that reporting on how businesses measure the effectiveness of their modern slavery responses remains a key weakness area. I know there was a discussion in the Modern Slavery Act review about providing some more guidance to business on this topic, and it's a big topic and could be a whole other discussion. And then one final finding that I really wanted to zone in on was that fewer than 10% of statements explained how at least one potentially affected group or stakeholder, and here we're talking about things like workers, their representatives such as unions, migrant worker organisations, for example, were consulted as part of risk assessment processes. And this finding was echoed in a recent report called Strengthening Modern Slavery Responses, the Good Practice Toolkit. And that's one of the reports that Justine was actually referring to. It's by that coalition of civil society and academics that Justine and the Australian Human Rights Institute have been producing. So that report also identified that a lack of business engagement with workers and also with suppliers is a key area of weakness in businesses' modern slavery risk management responses. And that report suggests that this weakness is in fact potentially one of the reasons why there've been quite a relatively low number of actual instances of modern slavery identified so far, at least in terms of what we've seen in public reporting. So the UNGPs and the human rights due diligence process says you're supposed to consult with potentially affected stakeholders to help identify your risk. And this really helps just make your risk identification more effective, helps identify red flags early, and it helps you design effective risk management. So the Modern Slavery Act review actually responds to this issue and has a suggestion that one of the mandatory reporting criteria, should be amended, and I'm quoting here, to require the entity to report on internal and external consultation undertaken by the entity during the reporting year on their modern slavery risk management. And that toolkit that I mentioned that you can see on the screen provides a range of tips about how to engage with potentially affected stakeholders and also suppliers. So if you're looking for some guidance, that's a great resource to look into. Jasper, if you could pop to the next slide, please. So just to finalise my comments, I just wanted to continue on this theme of effective stakeholder engagement to help you manage your modern slavery risk. And I wanted to do this by reflecting on how the CAF certification process, at least in my view, helps support businesses with this human rights due diligence process, and in particular is quite unique in the way that it has that important element of ongoing and meaningful stakeholder engagement, in this case with cleaners and their representatives with unions. So on the left-hand side of the slide, you can see I've set out the steps in human rights due diligence from the UNGPs, those UN guiding principles on business and human rights. And then the right-hand side of the slide, you'll see I've highlighted how the CAF certification process supports businesses to conduct human rights due diligence in their cleaning supply chains. So I don't have time to go through everything on this slide. You can see it's very busy, but I just want to pull out a few points. So the first step of human rights due diligence asks businesses to identify and assess where the most severe risks to human rights and impact risks lie. So the UNGPs say this should be a regular process. It should draw on expertise. And again, it should be informed by meaningful consultation with workers or other potentially affected people. So the CAF certification process brings specialised expertise focused on the cleaning industry to identify labour rights risks in cleaning supply chains, which we know are prevalent in this industry. And they can also be flags, some of that lower level labour rights risks like overtime and wage theft can be red flags for situations where modern slavery may flourish. And then we have that unique offering from CAF, which is this ongoing meaningful consultation with cleaners and the union to identify those risks and address them early. So the second step in human rights due diligence is integrating and acting on findings by taking appropriate action to manage the risks. So CAF certification process assists this in a range of ways, including controls like the tender pricing schedule that Jasper mentioned, contract clauses. There's social audits, but not just social audits. You know, CAF recognises that they alone are not sufficient. They're just a snapshot of a point in time. So CAF also uses ongoing compliance checks, unscheduled spot checks, and that ongoing worker feedback piece. The third step is tracking the actions you're taking and whether they're effective. And I think CAF really provides, the certification process has a number of feedback loops which are really helpful for businesses, tracking against that 3-star standard. There's ongoing reporting, but also that regular feedback from cleaners about what is actually happening on the ground and whether improvements are being made. And then that final step in human rights due diligence is communicating with stakeholders. And CAF can actually help businesses that are being certified with case studies to explain the work that they've been doing, issues that have been identified and remediated, and provide a range of metrics. And then finally, we know under the UNGPs that businesses are expected to remediate harms that they've caused or contributed to, and CAF can help with facilitation of remedies for issues that are identified through the process. Jasper, I'll leave it there because I think I'm going over time, but thank you very much for listening.
Thank you very much, Lauren. I appreciate your contributions, and thank you also, Justine. I remind everyone to please add some questions. I'm going to begin just with a question to both of you in a related way and allow you to answer it as you choose. Justine, you mentioned that the review recommends dropping the threshold for requirements for reporting to 50 million Australian dollars. And I assume that that's sort of going to significantly expand the number of entities that would be covered. We see in the cleaning sector that there are numbers of cleaning companies that are, and also asset owners that are having to make modern slavery reports, but I think specifically dropping that threshold will bring in a more significant number of cleaning companies themselves, contracting companies. Are you familiar or aware of how that recommendation has been received and maybe how likely it is? And then the other part of this question is also, perhaps, Lauren, do you have some experience with companies that are on the smaller end of the scale, medium enterprises, smaller enterprises, who maybe haven't had experience or haven't had capacity with modern slavery reporting, what kind of steps they might take to prepare themselves for that?
Thanks, Jasper. In their submissions to the review, there were actually mixed views on the desire to lower the reporting threshold. And that is partly because at the moment, I actually don't think the 100 million plus companies are doing it that well. So do we really want to add in another few thousand companies by lowering the threshold? So you'll find that there are actually mixed reviews on that. I don't have a firm reading from the AGs as to where they're going with this. We've spoken to them, but they're sort of holding themselves back. We do expect the government to make a formal response to the review in the next couple of months. That may be something that may come in more in a staged manner. But regardless of whether it does, a point that Lauren made is that many companies that are well below the $100 million threshold are already involved in reporting. Because basically what the larger companies are often asking for is a modern slavery, the equivalence of a modern slavery statement from companies within their supply chain. And many of these are below 100 million. So I think the days of sort of burying your head in the sand and saying we don't have to report because we're 100 million, we're not 100 million, or we're not even 50 million, are well gone. We'll also see with the law in the EU, that is going to have really broad tentacles, and that will affect companies across the world. That will also be below those thresholds. So whether that will be introduced in the short term is unclear, but I think regardless, companies are going to have to start to get their head around, if they haven't already, modern slavery reporting, because you will be caught up in a more informal manner in relation to it.
Thanks, Justine. Yeah, echoing your comments there. I think I agree, sort of a key reflection working particularly with larger businesses with Pillar 2, we can expect that if smaller businesses are going to be reporting, there probably is going to be some significant capacity building and support needed, hopefully from government. And that's also just to make sure that the reporting that's done by these smaller entities is actually having the intended effect. For example, to ensure that it's actually useful for customers, it's useful for investors, in that they're quality reports that are able to be relied upon, and also to ensure that the actions that they're taking with the resources they have are impactful. And I know one of the recommendations in the review report is that if the threshold is lowered, that perhaps there could be tailored guidance for smaller and medium sized businesses about what modern slavery reporting and complying with the Modern Slavery Act means for those in that lowered reporting threshold space. And I think Justine's point is really correct, that a lot of smaller businesses are already being at minimum surveyed by their customers about what steps they're taking to manage their own modern slavery risks. So they're saying things like, do you have a human rights or a modern slavery policy? Do you do any screening of your own suppliers? Do you have migrant workers? And do you have any protections for their labour rights? So it might be that there's, as you say, a sort of staggered approach, but there are probably already drivers for these businesses who they're already being on notice that their customers are interested in the risk management approach they may be taking or may not be taking yet. And I'd say in terms of smaller businesses, if you're looking to start to think about how might we do this for our own business, probably two key takeaways, which is firstly, under the UN Guiding Principles on Business and Human Rights, this human rights due diligence process is aimed at prioritising your most severe risks. You do not have to boil the ocean. The idea is that you find out where your most severe risks lie first and you take action there. So that's what one takeaway I would give for smaller businesses. The second is you will have the benefit now of 3 years of reporting, 3 years of additional guidance, 3 years of a lot of commentary coming from civil society, from investor groups, from academics about how to do modern slavery reporting, where to start. There are examples in statements that you can find on the government's online register that have been, you can look at the benchmarking reports to see, who's doing a good job and have a look at their statements and see where you might eventually be heading. I'd say the third, I'm going to add one more, which point would be, if you're looking to get started in this space, I think it's also about socializing it within your business. It is a bit of a cultural change, and making sure you have some buy-in at the top is really important.
I'm just going to reflect, there's a question that's come through on the chat. And from one of the participants, and they've thanked us for the presentation, and they say, in the table we see mention of worker voice, and it's quite an important issue in relating to risk assessment and management. But since workers themselves might have interests in companies, as in their jobs, they might fear losing those jobs or their interests. Are there any protections for them in these processes? Justine or Lauren?
I'll let Lauren respond first, since it was in her.
Sure. So look, it's an excellent point. And I think there is a whole body of work being done at the moment around what worker voice means, which includes taking a rights compatible way, if you're a business, to engaging with workers, which means making sure that they are protected and they're not fearing reprisals if they do talk to you and they do give, an honest account of what's happening in the business. So I would say it's an excellent point. I was, in fact, even in the good practice guide that I mentioned that, and sorry, Justine, if I'm stealing your thunder here, there's some great tips around doing investigation to ensure that, for example, if you're engaging with a union, perhaps overseas in a place where unions are repressed or have to be affiliated with an employer, that you're aware of this type of context before you start your investigations. Justine, I'll add one more thing, which is, I guess, the CAF example is really important here because there is the independent training for CAF representatives and engagement with the union that provides safeguards around the type of issues you're raising.
Yeah, I agree with Lauren. The short answer to this is CAF. So CAF is a mechanism that is set up deliberately to have to give workers a voice. Also working with the union, it provides them a protective mechanism around that. What I find sometimes working with businesses is that they go out of their way to make things more difficult than is necessary in relation to human rights due diligence. Workers are the best monitors of a workplace. They know what's going on in the ground. They know when there are improvements. They know what are the small and big issues that they're facing. And what the key for businesses is to figure out how to engage with them. Obvious ways are through an organisation like CAF, by working with a union, by working with a trusted NGO. In some cases, in some countries around the world, it is difficult to speak directly to workers and to get that. And so it's then looking at who is their voice on the ground, who do they trust? Part of that might be using certain technology and apps, and our good practice toolkit talks about some of those. But generally what you're seeking to do is find a mechanism where workers have some trust in the process. And that usually is technology plus something, a connection with a human, that they understand why they're doing this. But the role of workers, human rights due diligence is largely meaningless without workers being involved. And so you have to think about how you do that at the same time while safeguarding workers.
And I might just add, could I make one more point, which I've just sort of listening to Justine, which is, I think it also comes back to your relationship with your suppliers. So are you setting up an expectation that if you find something wrong, you are going to be terminating that relationship? Or have you set up an expectation that if something is found, if workers are raising an issue, you're going to collaborate with that supplier and help them raise their standards? So you can there's many drivers that you can use to help facilitate an environment where the workers are going to be comfortable speaking up.
I mean, I would just add to that in CAF's experience, there's a fairly clear relationship between, the engagement with a union, the level of membership at a site with who are engaged with a union or union members, and the risks of kind of modern slavery or exploitation of workers. And they're fairly, direct relationship, that we're far less likely to find problems on a site with where there's a union engaged than in sites where there is no presence of any kind of independent worker voice. We're almost out of time. I've got one last comment, and I guess this is the sort of the stick kind of question. At present, there are no penalties in the Act for non-compliance, and there are recommendations in the Act now in the review, I should say, for non-compliance. What are your views about the possibility of those penalties being introduced?
I would probably say 100% they will be introduced into a revision of the Act. How soon that will be, whether they'll be staged or not. Over the last 3 to 4 years, one of the clear deficiencies of the law has been the lack of enforcement. And so basically what we did in since it went into operation 2018, 2019, was set up a law and then said, let's hope it works, but let's not actually ensure compliance around it. That idea has proven to not be working. And so there will be a level of compliance. So the penalties will be one thing, but the more important, focus, as I said, is on this developing a relationship with suppliers, with workers, that leads to a partnership. So penalties can hang in the background, that they will be there to ensure some of that compliance. But if you don't do that setup work, that due diligence, that relationship building, then the idea and the purpose of the Modern Slavery Act loses all meanings. So I think that's useful to have, but I don't think everything will hinge on the penalties.
I think Justine said it all there.
There's a question just says, should it be financial penalties we're looking for or legal repercussions?
Well, I guess my view is it should be more than financial penalties. I think we should be thinking more broadly around an enforcement framework where one aspect is financial penalties. We should also be looking at the role and liability of directors in companies and the executive. We could learn from aspects of enforcing anti-corruption measures where there is a much broader enforcement framework. I think we will develop those over time. We're also seeing that in some of the laws coming out in the EU. And it's very important also, I think, that we develop a mechanism for workers to be able to hold companies to account when that's not followed through. So I think that broader enforcement framework will develop over time, and financial penalties are just one aspect.
I'd just sort of like to add to that point. I think, the questions around ethical procurement, and we know that, the federal government, state governments are some of the largest procurers of services throughout the Australian economy. And we know that state governments and Commonwealth governments are introducing mechanisms and have mechanisms around ethical procurement procedures, which include sanctions to exclude companies who breach kind of, legislation over specific compliance issues. So I think those sort of, they're part of the environment already, and it looks like that they will be potentially strengthened. I really appreciate everybody's time and their contributions. I'd really like to acknowledge and thank Justine and Lauren, who both have very busy schedules and have taken the time to contribute. I'd like to thank all the participants, to those of you who have observed and to those of you who have contributed questions. I'd like to indicate that this material will be available on our social media channels, and we will kind of advertise, we will put together a presentation pack so that you can download that and use it. And finally, I'll just comment on one last question that's popped up. We do have CAF materials that are available in work sites and where there are certified sites that have been undertaken by CAF. and we will continue to hopefully expand the presence of CAF in those environments. Once again, thank you very, very much for all your time and presentation, and we look forward to doing this again. Thank you.